Yes, Mr. Sarma.
Yes, my lord. In fact, I'm grateful to my lord, the Chief Justice, for the steer. If your lordship sees the instrument of accession,
Yes.
and this is in document 1, volume 1, sorry, page 9. Your lordships have it?
Yes. Just one second.
Yes. My lord, Justice Suryakant has it. If your lordship sees, it's very interesting.
Page 1. Sorry, page 9.
Clause 1 is the accession.
Yes.
He says, I hereby declare I accede to the dominion with the intent of the Governor General of India, so shall by virtue of this, my instrument of accession, but subject to the terms and for the purpose of dominion, exercise such functions as may be vested by them in the Government of India Act as in the Dominion of India on the 15th day of August. I hereby assume the obligation of ensuring that due effect is given to the provisions, etc. Now look at 3, Mama. I accept the matters specified in the schedule as the matters with respect to which the Dominion legislature may make law for this state.
So this is B1.
Yes.
This corresponds to clause B1.
Yes, my lord. And this was in a schedule which I'll show your lordships in a moment. I hereby declare that I accede to the Dominion of India on the assurance that if an agreement is made between the Governor General and the ruler of the state whereby any functions in relation to the administration of this state of any law of the Dominion legislature shall be exercised by the ruler of the state, then such agreement shall be construed and have effect accordingly. Now, my lord, comes the most important thing. In 6 says, nothing in the instrument will impart dominion to make any law authorizing compulsory acquisition. Now, this is interesting. This is a carve out from the legislative list principle. But I hereby undertake that should the dominion lie, etc. Now, my lord, 7 is important. Nothing in the instrument shall be deemed to commit in any way to the acceptance of any future constitution or fetter my discretion. And nothing in the instrument affects the continuance of my sovereignty and over the state, save as provided under the instrument. Now, this was the instrument of accession, but the Constitution, finally, if the lordship now matches this with 370, and I'm sorry, my lord, for completeness, the schedule your lordship will find in volume 4, page 176.
So basically defense, external affairs and communications.
Correct. Now, my lord, what happened? But what the spread in 370 corresponds to is very important. 370 starts by saying the Part B provision will not apply. 238 will not.
Right.
Then it says the power of Parliament to make laws shall be limited to those matters in the Union and the concurrent list which in the consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession. So this was on the issue of the legislative list and that schedule. matching them with our 7th schedule, and the president would decide how the 7th schedule is to be divided. And here it's only consultation consistent with the philosophy that accession and instruments of accession, these are what are in international law called political documents, not political in the political sense. Political documents.
I think, Mr. Sarve, it's very clear now. If the president wanted to make any exceptions or modifications,
yes,
in respect of defense, communication, or external affairs, then only consultation was required.
Correct. Now, my lord,
of the first proviso to clause D.
Correct. Now, my lord, applying other provisions of the Constitution, and my lord, I don't have to give your lordships a catalogue of which are the other provisions. I mean, there are so many important provisions of the Constitution. They would be phased in and applied under D.
Right.
And for that, they said concurrence.
They would require concurrence.
They would require concurrence.
They referred to either defense,
correct.
The
legislative lists,
affairs or communications.
Broadly, let us say the legislative lists are put to one side because that is really power to make laws. Yes. But what institutions, your lordship's jurisdiction under 32, for example.
The Constitution also, yes.
Your lordship's jurisdiction under 32. Should it extend or should it not extend to Jammu and Kashmir? These are, and what about public service commissions? What about election commission? So on and so forth. So all those were provisions to be applied if necessary with adaptation. Now, what is important? And I come back therefore to my point. How does this align with a complete accession? Article 3 is the answer. That this is an arrangement for the phased introduction of the Constitution, keeping or reserving unto the President the power to disapply this article. Now, obviously, for that, there cannot be concurrence. So it makes sense. Recommendation if there is a Constituent Assembly, otherwise the action of the President. This was the arrangement, this was the compromise. And my lord, this compromise was not just with the state of Jammu and Kashmir, the solicitor has placed before your lordships the sharp differences of view even in the Congress Working Committee. They rejected this plan. First time when Shri Gopal Ayangar presented it. Sardar Patel's letter is cited in the solicitor's list of dates. When he said, sorry, I don't accept these. So this was a very matter with more than one point of view and competing points of view. So this was the compromise formula, which is incorporated here in the Constitution. This was the workable arrangement. This is all right. Ultimately, we will decide and we will keep to ourselves the power to disapply this article. But if this works, phase by phase, introduction of the Constitution, why not? And it did work to a large extent. So, my lord, that principle, which my lord the Chief Justice was pleased to put to me, about lesser power and larger power, would it not require greater safeguard? That would not occur. That's what I call the contextual argument. I am not finished with this, and I have eye on the clock. If there's anything more, I can assist your lordship on this point. Otherwise, let me move to my next point.
I think we can move to your next point, Mr. Sarve.
Yes. Second point is, my lord, there has been some arguments about even if 370 applies, no radical change. And Delhi laws was citing. Now, my lord, some cleaning up, because some principles need to be clearly stated. the Birla cotton mills in Reed Delhi laws, the power to extend laws. You cannot make a radical change. Well, that can have no application here. That principle can have no application here. Because your Lordship has seen those cases. Your Lordships read down the power to extend and apply laws under Article 14. The argument was excessive delegation. You have conferred upon the executive the power to change a law made by Parliament and its application. And that is why your Lordship said we read it down. That the philosophy, the basic policy of the law cannot be changed, radical changes cannot be made. My Lord, 370 is a part of the Constitution itself. There is no question of excessive delegation. This is a power conferred on the President. And that is why my Lord Lakhanpal rejects this approach. But I was giving your Lordships an answer on first principles.
Yes.
The power, my Lord, under 370 is plenary in nature. And this is a power conferred by the Constitution. A plenary power is not subject to the principle of, or is not amenable to a challenge of excessive delegation because the Constitution has made this delegation. Where Parliament makes a law which is subject to Article 13, or where the state legislature makes a law which is subject to Article 13, then an Article 14 challenge can be brought saying this is excessive delegation. And all the Delhi laws, in Reed Delhi laws downwards cases, all dealt with excessive delegation. In statutory provisions on the anvil of Article 14, it is completely irrelevant to 370. Your Lordship has already said this in Puranmal, but I wanted to just put it on first principles.
Yes.
The second, my Lord, point is that the power exercise is legislative in character. I don't think I need to belabor that point very hard. Applying provisions and disapplying provisions, modifying provisions of a law is legislative in character. I don't think I need to cite authority for that matter. To suggest that this is an executive power is like saying ordinance making is executive power. And it is done by orders, Malad. I'll just give your Lordship a citation. The Meghalaya case with Schedule 5, for example, of the Constitution. 1972, one Supreme Court case is 148, just for reference. Where your Lordships have said that, because there also the President can by order say this and by order say that. Your Lordship. So this is now what follows from a plenary power and a power which is legislative in character. It has a direct bearing on the next issue of the extent of judicial review, of the exercise of that power. Because that one logically takes me to my next point, that the Ajit Mills principle, as Justice Krishna had explained in Ajit Mills. In the context of a law made by Parliament, if you say this is abuse of power or colonial legislation, it's an argument of competence, not of motive. That is one of the Ajit Mills principle. Your Lordship knows when the first law was made, saying if you collected illegal sales tax, which is not chargeable, if you collected, you pay. The argument was this is tolerable legislation because you're taking away. And Justice Krishna's answer, Manoj, I'll just give the page and para numbers, 77-4 SCC, page 98. Manoj, this is attached to my note. Manoj, this is attached to my note starting from page 6. Page 4, sorry. And the relevant paras.
But Mr. Salve, even if it is a legislative power,
Yes,
as you say it is, probably it is, it's amenable to judicial review on the ground of Article 14. A legislative power cannot be challenged on the ground of malefides. So you cannot
Exactly.
say that Parliament did something because of a malafide intent, because you don't attribute malefides to a collective body of individuals. That's the reason for it.
that's correct, Manoj. More than that,
Nagaraj, when they reduced the age of retirement, our court said you can't challenge the reduction in the age of retirement on the grounds that Parliament was acting malafide, because it's a collective body. Malafide is something which you attribute to an individual.
more than that, Manoj, your lordships have always said, where it comes to colorable device, supplementary, and all these, as it is Manoj explained in this judgment,
Actually, they started that.
it is really a competence argument.
Colorable exercise of power in Tulloch, our court said, it really means that though you are
Competence.
purporting to exercise power under one entry, you've
Yes.
actually transgressed into another entry. So it's really a question of absence of power, legislative.
It's a competence argument.
The competence argument.
Yes. And it's not the Wednesbury unreasonableness. have no application to an Article 370 sub-Article 3 situation. Of course, legislative power you can, if you make a rule which is plainly discriminatory, you can strike it down on violating 14. Of course. Because if Article 13 applies, which Malad in fact brings me
part of the original constitution.
In fact, Malad, which brings me to my next point, and I'm going quickly now because your lordship has seen the point. That this repeated reference to basic structure, Malad, quite frankly, even in some of your lordship's judgments, I find a little surprising. Basic structure was not a principle as a independent standalone constitutional right. Basic structure is the limitation inherent in 368. And constitutional amendments are tested with reference to the basic structure doctrine. But there are some judgments which do say this law not only violates 14 but violates the basic structure. Laws, strictly speaking, if you
don't violate the basic structure.
Laws can't violate basic structure. Laws violate part 3 or don't violate part 3.
You know, in 2 judgments, though, we have said that a particular law protects the basic structure. One.
But laws are aligned with the basic structure.
Places of Worship Act in Ayodhya, we said that is in pursuance of the...
Correct. But laws...
The second, we said that the introduction of the amendment for Delhi in 239 AA was in furtherance of the basic structure, which is...
furtherance of basic structure...
So there's a little bit of...
let me try and, in my very humble submission, when a law is made to protect civil liberties, 21 is a part of basic structure. A law made to protect civil liberties is a law aligned with Article 21 and therefore aligned with the basic structure. Now, one may in a flourish of language say it is to further. Today, if there are checks and safeguards built into arrest, checks and safeguards built into criminal trials, etc., you may say this is to protect the basic structure, because the basic structure is the trilogy of rights. Now, that is not to say that the law was tested on basic structure.
That distinction you've made, yes, of course, because as a doctrine, it was evolved to test the validity of constitutional amendment.
The problem is, Malad, one thing is to say something is aligned or not aligned with the basic structure. But to say that an exercise of power under 370 can be tested on the basic structure doctrine, I submit is a misconception. 370 itself is a part of the original prestige constitution. And that confers the power to disapply the constitution. This is no longer res integra, my lord. Your lordships have right from Rajasthan and Union of India, Bomai, chiseled this law and said, up to the stage where Parliament approves, don't do anything which is irreversible. Thereafter, you may. Because everything in one sense is irreversible. Man. What Parliament does is also irreversible. Parliament passes the budget for the states. It takes over the coffers of the state. What money is spent is irreversible. The money is gone. That's the way it is. The president may not dismiss people, appoint people, create institutions, remove institutions. The governor may do, the president may do under 356. Those are for those people irreversible actions. That is why your lordship has said 356 is draconian and should be very sparingly used. If the unfortunate circumstances require that for a defined period of time, the system of governance is changed under 356. If those unfortunate circumstances exist, and a very narrow area of judicial review is permissible, it doesn't arise because there is no challenge before your lordship. A bald prayer without the necessary averments, the challenge. Then, my lord, one has to accept the consequences of 356. But that's in the alternative. If I am right on my construction, my lord, of the proviso, quite frankly, minus the Constituent Assembly, it fell away. So you just added the state legislature and then you acted for the state legislature. Nothing dramatic really happened. If one ignores that also, if we are right on the proviso, then none of those questions arise. That, my lord, is the submission, unless there's something else I could assist your lordship.
Thank you, Mr. Sarve. That would be all. Thank you, Mr. Sarve.
Much obliged.
Yes, Mr. Sarve.
With the leave of my learned friends, I try to be as possible to conclude my submission. I don't want to eat into their time too. A couple of things the lordships will notice in my written submissions, page 41. I have the lordship's leave. I have a 2-page note.
Yes, certainly.
Which I have forwarded to the master. It's like a summary of my submission. No, it's been given to the.
We just upload.
Before I did, it's open before that.
Yes.
So I say there is no constitutional injunction barred that during the imposition of the President rule under Article 356, any measure under Article 370 cannot be undertaken. So I say they can be undertaken. So the following orders which are spelled out in the paragraph 2 are examples of such exercise of measures. And thereafter, let's just make a note of 2 or 3 paragraphs here. Paragraph 5, paragraph 6, and then paragraph 7. May I just read paragraph 7. This is at page 42, my written note. 66. Because they try to point out in the footnote that the canvas which needs to be addressed is of such complicated issue that it won't be put in a straitjacket. So I'll say in paragraph 7, with all political choices or political action may not be free from the scan of judicial review, this would be a qualified statement. The combination or choice of measures to be undertaken by reason of the duty imposed under Article 355 and the authority always available under Article 3 of the Constitution of India will all be matters of a class of decision making and deliberation which will deserve deference and not scrutiny. May I qualify being and not strict scrutiny, if I put it like that. Then also kindly make a note of paragraphs 9 and 10 in the same sequence. Particularly paragraph 10. Page 43. And that follows that extract from Bommai. Very carefully worded provisions about the political ticket and questioning the political wisdom, etc. Following that, paragraphs 9 and 10. We just quickly read them. S.R. Bommai principles on justiciability of the exercise of power by the President may not be mechanically extended to circumstances of imposition of President's rule in the context of matters such as external aggression and internal disturbance, and more particularly in the context of the dynamics in relation to the border states. In paragraph 10, consequently, CO 272, which can be treated as a product of consolidated stock taking of decades of internal disturbance, and unrest in the state of J&K is a valid exercise of power by the President to achieve a larger constitutional and public interest aim. That's how that aspect ends. Then, on scope of 356, kindly turn over to page 47 of the written note. I'll just quickly take your lordship through a few paragraphs. In paragraph 1, I talk about the preamble, and paragraph 3.
Yes.
And thereafter, in paragraph 4, I'll quickly read that. On a plain reading of Article 356, it is obvious that the makers of the Constitution deemed it fit to give a very wide and extraordinary powers to the President in Article 356. Such power the President can exercise either in the receipt of a report from the governor of state or even otherwise, on being satisfied that a situation that is in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, the President may proclaim any and all of the following. So having regard to the amplitude of the powers, then kindly turn to paragraph 5. That's why in Badrinath, we'll also just make a note of the judgment that's available in volume
Badrinath was cited by the
That's right.
solicitor. Yes.
Just paragraphs 25 and 26 of Badrinath.
Yes.
So kindly make a note of those two submissions in paragraphs 5 and 6 here. Also, please make a note of paragraph 8 where we have set out how proviso to Article 3 has been suspended during presidential proclamation, Article 356. In the following case, we're given a list of all those cases when therefore it is not something a departure here. It's in tune with the constitutional practice.
Suspension.
Sorry, where is it gone?
The other things, Bommai and Badrinath, we've of course seen the solicitor cited both the judgments. So.
Just make a note of those paragraphs which is spelled out, paras 10
We've
to
got
13
that,
in this
we'll
note.
read that.
Then I'll quickly run through this. Kindly turn to page, please revert back to page 16.
Go back to 16.
Try to talk something about the sovereignty issue, the division, and then you have the thesis that you have retained something with you.
Good.
we'll do is we'll go through the submissions in the evening today.
Your Lordship, please.
If there's some further query, then we can pose it to you in the morning.
Can I just
tomorrow,
quickly
just for two.
therefore take your Lordship so that 2-page note we just, then I'll complete.
This one. Yes.
We proceed to read it. Where is it? Okay. Where do you put it? This thing. The process of constitutional integration of J&K bears all the resemblance with the process of constitutional integration of various territories of India, namely democratization combined with the merger of small states, formation of union state, the idea of having constituent assemblies for framing constitutions, etc. There was no distinct or special compact between Union of India and J&K as far as the constitutional integration process is concerned. The political compulsions which intervened in the case of J&K resulted in the formalization of the process of integration as enacted in Article 370. This formalization of the process has no flavor of a distinct special or a special compact, the object being constitutional integration. May proceed. Then 2, various 3 is about Article 317 on behalf of the petitioner, the self-serving propositions away from the text and context of the provision and the intent and content of the provision. The context, namely the deliberations required for the extension and applications of the provisions of the Constitution of India and J&K to J&K in order to suit its needs and requirement and its ultimate constitutional integration is the object of Article 370. This process is expected to be completed in the course of deliberations by the Constituent Assembly at one level, having regard to all the constitutional orders issued before 1957 and Section 5 of the J&K Constitution. It can be stated the process of integration was complete. At another level, taking stock of the issuance of constitutional orders by the President beyond 1957, the majority of which is in the nature of constitutional updating. It can be stated the updating has been perceived as a continuing link. It is open to the President to take a final stock of the exercise authority under Article 371D and to decide as to whether there is a need of updating exercise at all or the need for any other invocation of Article 371D. This power of the President is not limited or conditioned by any practice in relation to Article 370 in the past. All propositions relating to sovereignty, external or internal, divided or shared, are completely inappropriate in the context of J&K. There is no distinction between constitutional integration and assimilation of J&K and the other parts and territories of India which integrate the Union of India. There is no basis for an artificial line drawn between internal and external sovereignty. All statements about federalism are based on political practice. What matters is the arrangement of powers and authorities in regard to the units of the federal structure. Once the arrangement is drawn on the basis of submergence, if any attribute of sovereignty is only the arrangement to be looked into. There can be no room for any subsisting elements or attributes of sovereignty thereafter. Part 18 of the Constitution of India is a composite scheme calling for its flexible application, having regard to the fundamental mandate of securing the integrity and unity of India. The application of provisions of Part 18 in the case of border states and the appreciation of factors to be reckoned in the regard will not be justiciable. It is open to the President and the Parliament to act both under the scheme of Part 18 and the plenary powers under Article 3, which is not conditioned by the provisions of Article 356. No rights in relation to representative democracy have been taken away. Reorganization of states include temporary or other rearrangement rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if the unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measures of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to exist or continue. However, it is submitted that all measures taken within due process are granted and to be pressed into service to act in exceptional circumstances. That summarizes the submissions, and you also I'll give a skip note onto my written submission to indicate which part probably will come in a certain sequence. That's good. I am thankful for your Lordship's kind indulgence.
Thank you. Thank you.
So let me begin with a deep breath. 14 days of wait, and with some hiccups. Finally on the pitch. However, my lords, we are dealing with Kashmir, my lord. If one goes to Kashmir, my lord, 14 days are not enough. I think Mr. Zafar, I will vouch for that. And even a month will be, my lord, less. There's so much beautiful scenery and so much beautiful and nice people, my lords. And a nice culture. So what one thing is there, my lord, with this proceeding, the learned councils, what name? When you play a match on the pitch, then you don't watch the scoreboard. Oh, you forget it. So one thing is clear, my lord, that the learned councils on my right, my lords, they have very ably, my lord, put forward the case for the rights which the people of Kashmir, or at least some of them, feel vest in them, and the desire to see the continuance of 370. Nobody can say, my lord, that the lawyers who are not from Delhi, they have taken full care, my lord, of the interests of those who believe in the continuance of 370, and even the world who is watching should see, my lord, that the emotions with regard to Kashmir are not only running in the veins of people of Kashmir, but the whole of the people of India. They are concerned with Kashmir. One way or the other, that's a different matter. Which way the judgment goes is another matter. But we are all concerned with Kashmir. That's the stature of Kashmir, Lord, in the hearts of all the people, Lord, 1.40 crores. Lord, the other aside is, Lord, that I was wondering, Lord, taking a cricketing analogy, just a little aside, Lord, that when we walk into the pitch, the opening batsman, Lord, one finds with the guards and thigh guards and elbow guards and helmets nowadays. But our Lord, opening batsman, Lord, the learned Solicitor General, when he walked up, he did not walk any pads, etc. Lord. And that reminded us of the period of Sunil Gavaskar, Lord. We never had wear Lord, the head caps and all that. Only the skull cap was there. So he didn't start by saying, Lord, that these constitutional orders carry the presumption of validity, Lord. These are all available, my lords, to the state to stand up and say, which your lordships, of course, keep in mind. One, that there is a presumption of validity, my lord, which they have to, the burden is on them to show that unquestionably, undoubtedly, the only conclusion is what they are confessing for. The second principle, my lord, is that if there are two views possible, my lords, with regard to 370, so Article 3. Then that view should be adopted which sustains the exercise of power rather than it defeats that exercise of power. So the burden on them is to show that what they canvass for is the only view possible.
Mr. Dwivedi, which eye are you appearing in? I'll be just like.
I'm appearing in writ petition 1070 of 2019. And I'm sorry, IA number 84479 of 2022. I apologize. In writ petition 1070 of 2019 and writ petition number 1162 of 2018. Both of them are by the most popular PIL petitioner in the court today.
Ms. Manora Sharma.
No, listen. Nowadays he is not that popular, Mr. Upadhyaya.
Oh.
Your arguments, Mr. Dwivedi, have to be very brief.
My argument was?
Arguments have to be very brief. Because Mr. Upadhyaya feels that a delay in justice is occurring, so therefore there must be very, very concise arguments and finish. That's his view in public domain.
In fact, one question which has troubled all of us is when my Lord the Chief Justice asks how much time you will take. So, now being towards the end, it won't be too long, but let me see how crisp I can be. So these are the two fundamental basic principles. And in constitutional matters, it's always possible to take two views. Even if the basic structure doctrine was 7:6. So these are all always highly debatable. Ultimately, your lordships have to decide which is a better proposition to take place. Just as in that case, what tilted the balance was that if an absolute power is granted to amend every part of the constitution, then many of the fundamental values can suffer destruction. So therefore, that caused the tilt. But there also, your lordships did not say basic structure cannot be touched. It can be abridged, but not destroyed. That was the concept. So coming to 370, lords, I have some divergence from what Mr. Salve submitted. It's not in opposition, my lord, to what he generally submitted, but some divergence. In our camp, my lord, fortunately, there is little divergence and contrast. Unlike, because those who are claiming that that's the only submission, I find a lot of contradictions amongst the lawyers stand. Some saying something trying to say quite opposite to that. But that apart, my divergence is about the character of the power of the president. Mr. Sibal said it is executive, president's power. Mr. Salve says it's legislative. I say, my lord, that this power is a constituent power, much wider than Article 368. The fact that it is vested in the president is for the special reasons which existed when it was framed. It's a constituent power. A power, because the lordships in the 5 judges' judgment say, Puran Lal Lakhanpal 2 probably, that modify is very wide. Efface. You can say even 136 will not apply. Ordinarily, independence of judiciary, if anybody touches 136, it will be struck down as violating basic structure. So the power to modify and accept under D is very wide. Well, there are 5 kinds of constituent powers in the Constitution.
Yes.
The first was the original constituent power in exercise of which the Constitution was framed. The widest term, you could have framed anything you wanted. Whatever kind of federal structure you wanted. The second word is the ancillary constituent power. That is something like Article 238 was that for certain period of time, the federal structure stands suspended, the central government will control Part B states and develop those structures and ensure that it comes up at level. And that's very important. It doesn't apply to Kashmir, that's one thing. But the idea was that the central government should take steps to bring it up at par, those states, Part B states. The other was 306. In the chapter of free trade and commerce, where certain states were very much interested in continuing with the power of taxation, particularly Travancore, Cochin, because being on the port, their entire income was found based on the export and import duties. So therefore, 306 permitted for a certain period those states to impose, levy and collect tax. The 370 is another power, of that kind. All three, the purpose is to have some time period, some temp period, so that bring it to the level of the normal federal level. Asymmetry, is a completely different concept. Some tribal area may be lagging behind, some state may be lagging behind, some state may have some special features, so you may for some time allow them certain special treatments. All these detailed provisions which are read out to your Lordship, 371 G2, dealing with the Northeast and Andhra Pradesh, Mizoram, etc. They have nothing to do with bringing at par. That is to protect the tribals and so on. But these three articles will not stand on a different footing, and their objective is to give a certain breather certain time, so that in due course, of course, the manner of alignments, how it will be brought in are different. So
Article 238 was not limited in time, right?
no, but ultimately by 56 it was
Right. It was
intended to be a permanent feature. That's what I mean to say, Rose. Under the policy documents, which I will read out to your lordships to the relevant portions only, would show that the idea was because the different Indian states were in a different state of development. Some Malad was so small they could not hardly afford to have a legislature, etc. I know. So state structure could not be supported by them. So like even in Himachal Pradesh, they had to be collected and put in one, so many union of states had to be carved out, many small states had to be just merged. They could not afford to have a state. And though even those who formed a union, they hardly had a constitution, that it required a time period to build a constitution for the United States. So for various reasons, in various phases, things developed. And so finally, the federal structure which was formed, even at that stage, there were pulls and pressures. So certain compromises struck. And these three articles, therefore, are ancillary constituent power. They are continued. This is very significant, with the process. For example, for 370, the process which started with the framing of the constitution, it was understood, that this is to last. They don't fix a time period, though they have put it in part 21. No specific time period is put there, but it is expected, that in due course, as Nehruji and Gulzari Ji said in their speeches as prime ministers, that slowly B1, B2 and D will be used, and the alignment process will happen, and slowly a time will come where really nothing remains, then put them at par and finish it off. This is meant, therefore, to slowly align it, bring it at par and terminate it. So it's that continued process, and that's why it's an ancillary constituent power. The third is, the amendatory constituent power in 368. And in the context of 368, I will just give your lordships the paragraphs, separately, of the different judges, who held that the power under 368 is constituent, and that's why Golaknath was overruled. Though ultimately in the process, what was created was the super Golaknath. So the limitations were in Golaknath were only fundamental rights, but now it's a much wider domain. But essentially, what I rely upon on those portions where the ordinary law and the constituent power have been distinguished. And the distinction pointed out is that where you are amending the constitution, constitutional provisions, then that power is constituent power. Ultimately, 368 so therefore, and if you compare 368 and 370, located in the Constitution in proximity, the width of amendatory power, at least as the law stands now, basic structure cannot be amended there. But here, so far, nobody has paid any heed to the basic structure. 35A has come in, and a whole lot of things. 136 was applied much later. So, Comptroller Auditor General came much later. So all the basic fundamental features, they were missing. So it's much wider than the amendatory power. So it cannot be described as an ordinary executive power of the president, or even a power which is legislative in the nature of an ordinance making power. So what your lordships deal with today is a constituent power. And this constituent power, my lord, is laced deeply with elements of act of state. Play field for the JK Constitution. So it's not only an unusual power, but a power which is of a very wide scope and wide impact, wide consequences, wide ramifications for the whole of the country.
Very significantly, any modification cannot be brought about by the legislature of J&K or under the Jammu and Kashmir Constitution.
Right.
Modification has to be brought about within the rubric of the Indian Constitution.
Indian Constitution. That's right. And one of the proclamations, the first one of the Yuvraj Karan Singh, as he then was that this Constitution of India will define the relationship between the state and the union. 25th November 1949. That's very important. I'm not reading it, you'll also have seen that. JK Constitution was not there. So this constitution will define, that's a very potent expression, my lords. So therefore, my lord, it's not an ordinary legislative power and when you, I'm so sorry.
Say if entry 82 of the union list is applied, the J&K, there's no provision in the, I just took 82 not for
Yes,
any
yes,
reason,
I
I just
understand.
picked up one entry.
Yes.
That there is no provision in the J&K constitution by which they can say that, look, we don't want 82 hereafter.
Yes, right.
Because the application or non-application of provisions of the Indian constitution has to originate within the Indian constitution.
They are asking for anything is insufficient, inconclusive, of no avail. Of course, I'm not belittling it, but after all, one state and union relationship is involved. If a state is asking for something, of certainly the union should consider and give it a thought and possible accept. But that's a different dialogue. It's not talking and speaking to each other as Mr. Gopal Subramanian was saying, and lot of talking and speaking and whispering also goes on in political sphere, in every law when it is made. Sometimes they meet outside in the lobbies and sort it out. Sometimes it goes to select committees and so on. So talking and speaking and whispering and all that is neither here nor there. That doesn't result in a compact. If something, two parties go outside and sort it out and then the bill is passed with some change or without changing. What happened when 370 was being tabled? Your lordships have seen, there was hardly any discussion. Because the government said that do not debate too much because the advantage will be taken by the warring state across the border. Before UN, there was no debate. And in 1952, Mr. N.C. Chatterjee said that at that time you did not allow us to speak, saying that Pakistan will take advantage of it. But now in 52, then he put up questions. Of course, Nehruji answered it. These are only not critical of anything, that one has to place oneself in those times and where it is difficult for us to go on a flashback in these cases. Difficult times. So he answered it then, but those questions were not put. So one can't put reliance on the speech of Mr. Anger or this or that speech of Mr. Sheikh Abdullah. They were divergent interest also, clashing interest also at that time in play. came from where? Northwest Frontier Province. After 2 terms, Mr. Cunningham, who had been governor with weapons of army. Pakistan army had just been split from India. And the biggest, starkest example is, Lord, who was fighting Lords. What is this POK today? 2/3 of POK is Gilgit-Baltistan. And who fought the war there, Lords? Not the raiders. It was Major Brown, who was the regent there. He was posted again in July, just before that, by Cunningham. And this is a book, Mutiny. He killed all the forces of Maharaja. Ansar Ahmad was posted there, and he was arrested. And he, in 4 days, he hung the flag of Pakistan and he had handed over to Cunningham. He sent some Mr. Alam from Pakistan army and he took over Gilgit-Baltistan. Where is the war with Pakistan? It is British. But if we close our eyes to all these, then it is the raiders fighting across floods. Raiders could not by themselves come up to Srinagar. The war had reached almost this Kardu and Kargil and to that closeness to Tibet, Leh. So it was a war of a different kind, but nobody could say it because Mountbatten was there, Lord, as the Governor General. Again, must have the leaders, our leaders must maybe having some reason that even though Lord Jinnah said, I will not accept any British Governor General, but the party said, no, we are ready to accept Governor, you continue with Indian Governor General. So what is this war? Governor General, and not only this, when the war began, Lord, they constituted a defense committee of the cabinet. And Mountbatten was made the chairman of that. So it's an excellent situation. Lord Mountbatten is the chairman of defense committee. Auchinleck is the supreme commander of forces. All generals are British and one Britisher is mutinying. And when he returns to England, he is given the medal of the British Empire. So that's not the position of the war. So when you read the Constitution and 370, please bear in mind these things, in what circumstances our leaders were moving through. And when we were about to push them back and recover the territory, they deliberately stopped the war at a point of time and got the reference to the United Nations. Because if you had gone up to Mirpur and behind, then that connection would have been off with Gilgit-Baltistan. Now, these are hard facts, nobody can dispute it. It is in these circumstances, Lord, and what was United Nations? The same very power which for geopolitical reasons, the US and UK, which wanted to partition India, they were the arbiters. Fortunately for us, Lord, Pakistan refused to vacate POK. So that resolution is dead. There's no need talking about United Nations, but at that time, look at the enormity of the situation in which 370 has been. We can't interpret it, therefore, Lord, with a tool of interpretative toolbox. Maxwell cannot answer this. Bennion cannot answer this. Grace cannot answer all this. None of the judgments so far which have been delivered in this court are helpful at all, Lord, to reach a conclusion, except Sampath Prakash, Lord, which dealt with to some extent with the situation after the expiry of the dissolution of the Constituent Assembly of Kashmir. That and that alone. The rest are all in different contexts. Principles we can help, take help of. But this situation, if lost sight of, creates problems, Lord, at both ends. you accept their contention, then this becomes permanent. There is a proviso under 368, we can't amend it. Go by the route of 370, and 370 is permanent, and therefore, Lord, we are left at the mercy of the local vested interest, which does not always coincide with people's interest there. So you therefore look at the consequences of both sides. On one side, if you accept our submission, the right of the people of Jammu and Kashmir gets expanded, and they don't suffer blood. Right to property is a matter of the rich and the neo-rich blood. The poor people, they're hardly 19(1)(f), they're hardly concerned. But even those smaller people who have small houses, etc., so certainly it has meaning. But then 300A is there, which virtually subsumes, now it's a human right under the Constitution. So nothing is lost, not even 19(1)(f). Nobody can confiscate because of 300A. So 31 and may not be exactly at par with 31, but substantially it is there. So nothing is lost. They are put at par. The basic structure of federalism is protected.
Consume tomorrow, so they will.
So far as involvement of Parliament is concerned, it comes in two ways. One is
Mr. Trivedi, just to sort of break your leg a bit, you spoke of there were 5 constituent powers.
the fifth one I have mentioned.
We got third. We have the original constituent power by which the constitution was
the
framed.
fourth.
Second was ancillary constituent power. The third was amendatory constituent power. That's the third.
The fourth, my lord, is like the provisions like Article 3 and 4, where amendment of schedules relating to states and their structure, etc., Article 3 and 4, they can be altered. And by a law of parliament, and it is provided that they are not to be treated as amendment under Article 368.
Then can that be treated as a constituent power at all? If it's not an amendment to the constitution.
No, so they are amending the schedule to the constitution. Their levels are different.
But the constitution tells us that it's not really an amendatory power.
So therefore, I'm saying that these are the 5 different ways in which the power has been conferred. This is one another way
All right,
where they say that you can make a change in the constitution. Because my postulate is that every change in the constitution itself, if brought about, is a constituent power.
All right. That's the fourth.
And the fifth is, my lords, Article 1C, where this court has held that if you acquire some other territory, then it says I'm sorry, Article 2, my lord.
2, not 2. Yes.
2. I'm sorry, Article 2.
Parliament may by law.
Yes. Admit new states on such terms and conditions that things fit. Again, my lord. Very wide. So while admitting, my lord, A, B, or C country, let's say, my lord, some bordering city of China, my lord. They are very interested in naming our cities, my lord. If that is admitted, just aside, my lord, polite rule. So if it is admitted, my lord, then the terms and conditions can be fixed.
Therefore, your argument is that the exercise of the power under Article 370(3) is a constituent power exercised by the
So
President.
your lordship's judicial review has to be on that basis. And it's when your lordships expound 370, it has to be with that in mind, my lord.
So the level of deference would be much higher than even the level of deference to an ordinary piece of
legislation. Executive order, then Wednesday principles and all those things will come in. Whether your lordships will bear judicial restraint, that's the other side of it.
That's the exercise.
Yes. If it is legislative, as the lordships put, Article 14, how it will come is whether it will succeed or not is quite another thing, but amenable is the lordships. But if it is constituent power, which is continuing and is part of the constitution making, part of federalizing, this is part of constitution making, part of federalizing Jammu and Kashmir at par with other states. I will read 2 state policies, one place before the Constituent Assembly by the State Department and the other the speech of Sardar Patel, where they spelled out the policy. This was a departure from that policy. And departures, are not permanent. Can never be permanent. The policy is states, that is the Indian states and the British provinces under the Government of India Act should be brought at par, at equal level. That was the policy. And placed in October and November 49, just before the adoption of 370. So 370 was a departure being made because of circumstances, political pulls and pressures and so on, and the circumstances which I narrated. So therefore, you have to therefore consider this as a continuing process which was meant to be terminated, and 75 years is a pretty long time, Lords, for federalizing Jammu Kashmir at par with other states. That means that the power was rightly vested in the president and was properly exercised by them. It was not that in 1957, one may ask not that if my contention is accepted, then immediately after dissolution of JKCA, the president could have terminated. Yes, he could. It's a high political policy. It's an act of state. There were some states where forces were sent. That can't be questioned, that how Hyderabad was brought, how Junagadh was brought in, how a referendum was done. All those things are in the past and they were act of state. Mr. Sibal said that had there been another route,
An act of state is executive, right?
So executive, nothing prevents the Constituent Assembly from putting a power in the Constitution itself. So that, it is what was expected was that the Constituent Assembly, when it sits, it might well take a decision that please align us at par.
What happens thereafter will be either in the realm of legislative power or the executive power. If we go by this.
So that's not right, Lords. And that's my contention. They are not very correct in that. It's not always, then 368 law is not purely legislative and executive.
Now, you are equating 368 also to constituent power. Yes, by saying that it is also a constituent power. That way it is. Whenever you will be amending the constitution, you will be making changes in the constitution. But that exercise cannot be equated with the constituent power for the simple reason. Constituent power has the power to go from a scratch, from 0 point.
Not necessary, Lords. A mandatory power is constituent.
Yes, a mandatory power is certainly
So this
there.
is a mandatory, Lords, look in much wider.
No, the question is not. Question is not that. The question is, can the mandatory power under 368 be taken to the level of constituent power as to go?
I never said that, Lords.
You're not saying that.
No.
So what you are saying, therefore, they're really speaking, there's jurisprudentially there won't be any difference.
There would be, Lords. The nature of power is completely different. Lord. That has to be realized. An executive power of the president is, for example, he recommends Lord, financial bill should be passed. That's a different kind of power.
That's correct.
So the president has a whole lot of role to play under the constitution. All roles are not at par. For high policy reason, this was given, Lord. No, but this proviso to 368 is because the government, Lord, of India did not want, Lord, to go through the route of 368 every now and then. So if you want to do away with 370, go to 368, then 2/3 majority, and then you maybe somebody will say state is affected, so ratification by majority of states. So an easier, because the policy was to put at par. Therefore, it was, since the policy is given, alignment is the question. Alignment may take such time, as the circumstances permit. Nobody can predict how much time it will take. So, and this was provided here. Keep also one more aspect in mind. The framers of the constitution knew that a president of India is a continuing office. It will not lapse after any point of time. Whether it is part of basic structure or not, But even if it is not, nobody expected that the President of India office, high office in which the executive power vests, will vanish. So it was a continuing power. They also knew that Jammu Kashmir Constituent Assembly is an ephemeral institution. So they had two institutions, one permanent, one ephemeral. They are being brought into a relationship in 373 with a notwithstanding. So now not an ephemeral expiry of an ephemeral institution impacts the permanent institution of the president. That can never happen, my lords. If that were the intention, what was so difficult in 370 to add a few words that with the expiry, my lord, of the JKCA, if I may use this short, JK Constituent Assembly, then, my lord, the main power will also lapse. The framers are very well aware of cessation of certain exercise of power after certain period. Be it 356, 352, ordinance making power, place in 6 months. If you don't place, it will lapse. My lords have dealt with Lord Krishna Kumar Singh. Even 249. So there are so many lords situations. They are aware. They are casting the languages of different provisions with this expression that it will cease for different reasons in different cases. Why is it that they are refraining here? Certainly, my lords, it could not have been in their mind, my lord, that this will remain for all times to come, my lord, till eternity, my lord. The relationship of Jammu and Kashmir, my lord, state as a federal unit with India will remain different for no reason whatsoever. And as my lords had put a query to them, if I may just adopt that. Supposing, my lords, through the route of with concurrence and consultation, my lord, everything has been adopted. Why do we want to keep this relic? For sentiments, my lords. So it has to go someday, my lord, somewhere. And what is it that remains today, my lord? It may not be a shell, but close to a shell. And my learned friend Zafar Shah said, my lord, we have sentiments. Yes, we understand that. If I live for too long, my lord, with a particular provision, my lord, there will be sentiments, my lord. No difficulty, my lord. We appreciate that, we honor that, we respect that sentiment. But equally, just a human life, my lord, the time comes when you have to bury it. We have emotions, we have sentiments, but we have to bury, my lord. We have to cremate. So that's what, my lord, is in mind, my lord, that please, therefore, my lord, your lordships are acting as a part of a constitution making process. This adjudication is not apart from, my lord, completely disjointed and disregarding that process. Most of other things your lordships have already noted, my lord, this temporary here, temporary that. They say marginal note, somebody says temporary is only object, my lord, not the time period. This is not the way, my lord, the lordships in Bombay have construed.